Famous personalities and the creators of well-known characters require legal rights to protect their reputations from being exploited in retail markets. But there is no agreement or contract permitting the use of a personality or character for marketing purposes. The tort of passing off can protect their interests. In Radio Corporation Proprietary Limited and Disney, Judge Dixon explained that an elaborate system of licensing has been set up. The types of goods produced may be unconnected to the characters, ranging from canned soups to cotton undershirts. He also commented that in relation to Disney merchandise, the use of a character does not create an impression that relates to the origin, selection, or treatment of the goods, and further, that in some vague way the buyer supposes that Disney must have sanctioned it. Therefore, the extended form of passing off can be used to protect the innocent party, where a trader makes the representation that the product or service has some association with a personality or character. This can skyrocket sales due to the level of influence exerted by public figures on the community. Passing off protects property through goodwill and does not protect the goods or services themselves. The plaintiff's goodwill must be injured by the defendant's acts. In order for an action in passing off to succeed, the plaintiff needs to establish its three elements, known as the classical trinity. Firstly, the plaintiff needs to establish that they have attained a reputation or goodwill in trade or business through their name, goods, services, and marks. In establishing goodwill, the courts in Australia do not require that there be a common field of activity between the parties. In Henderson and Radio Corporation, two famous ballroom dancers were able to restrain the other party from using their photograph as the cover of a dance music record. It was irrelevant that they were in completely unrelated businesses. The second element provides that the defendant needs to have made a misrepresentation to the effect of deceiving the public, or a representation that causes confusion as to whether the plaintiff is involved in the defendant's business. In the case of Children's Television Workshop Incorporated and Woolworths New South Wales Limited, the producers of Sesame Street had the right to grant licenses for the production of the Muppets merchandise. Meanwhile, Woolworths produced and sold plush toys which look like the Muppets characters. The court found that the public would be inclined to believe that Sesame Street was associated with Woolworths, as the public associates the marketable commercial goods with the party who has the authority to permit their manufacture. In the case of personalities, the person must be unequivocally identified, either through the use of their name, photograph, or other information particular to them, which causes confusion in the public's mind. In instances where the defendant clearly negatives any association with the personality or character, there will be no passing off, as there would be no confusion. It is irrelevant whether the defendant had an intention to misrepresent the source or affiliations of their goods or services. The final element is that the representation made needs to have either caused actual damage to the plaintiff's goodwill, or there is a probability that the plaintiff will suffer damage if a quia timet action is brought. The plaintiff can seek damages or an injunction to restrain the defendant's activities in a quia timet action. In summary, in order to protect character merchandising or personality rights and establish passing off, the plaintiff needs to show that they have attained a reputation, that a misrepresentation was made which deceived or caused confusion for the public, and that damage was suffered.